Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone, welcome back to Legally Speaking. I'm Melanie Van Orde, your host and paralegal, and today I'm joined by criminal defense lawyer Richard Aitken. We are discussing a critical step in any criminal case, the disclosure review.
Disclosure is a vital part of the legal process, and it's something every accused person should understand.
So after you're retained by a client, what is the first thing you do?
The very first step in any file is to order disclosure. Disclosure is essentially the evidence the Crown has against their client. It usually includes a police report, written witness statements and videos, the accused's criminal record, and sometimes additional materials like photographs or forensic reports. We order it, generally speaking, by email sent to the Crown as soon as possible.
And then when do you typically receive the disclosure?
Generally, we receive it and hope for it before the first court date. That ensures we have time to review and discuss it with the client even before the first appearance in court, and that we can take any necessary further legal steps.
And what happens if some disclosure is missing?
It's not unusual for disclosure to be incomplete initially. For example, we might not receive all video evidence, certain witness statements, or forensic reports. When this happens, we follow up with the Crown to request the missing pieces. The law requires the Crown to provide everything they have, so it's their obligation to ensure we get all relevant evidence at an early stage.
And then is the accused entitled to keep a personal copy of their disclosure?
Generally, no. Certain types of sensitive disclosure, videos of alleged victims, can only be reviewed at our office. And other videos, such as child pornography cases, the client cannot review at all. The lawyer is the only person who can review that, and at the police station. And that's, of course, because possessing that material outside the specific legal circumstances is illegal. In other words, lawyers cannot possess child pornography, even if it's evidence.
And then what happens if the police or the Crown loses the evidence?
Generally speaking, good news for the accused. If the police lose evidence, it's a serious issue. The defense can argue that this undermines the fairness of the trial. Depending on the circumstances and the importance of the lost evidence, a judge might decide to stay the charges or even dismiss the case entirely. A stay essentially means the defense has won.
And then after you've reviewed the disclosure, what are the next steps?
We review the disclosure with the client. They're welcome to take notes and watch most videos at our office. They can't take the videos home. This is to prevent sensitive materials like victim statements from being leaked online.
Well, that makes sense. So how long does it usually take to review disclosure with a client?
It depends on the complexity of the case. For a straightforward matter, perhaps a drinking and driving charge, it might take an hour or two. In more serious cases with extensive evidence, it might take several meetings.
What happens if the Crown produces new, unexpected disclosure right before or even during the trial?
Well, Melanie, this is called late disclosure, and it can disrupt the defense's preparation. If the new evidence is significant, the defense can ask for an adjournment to review it. In extreme cases, the late disclosure impacts the fairness of the trial, and a judge might impose sanctions on the Crown or even consider dismissing certain charges.
So, Richard, does the accused need to give their own evidence, like what they found out, to the Crown?
In Canada, generally no. The defense is not required to share its strategy or evidence with the Crown, except for in certain specific situations. For example, if the accused plans to use an alibi defense, they must notify the Crown in advance, in fact, at an early stage. Another example is certain social media evidence from the complainant, like in the Ghomeshi case. The law has since been amended, must be given ahead of the trial within a certain time frame.
And then after reviewing the disclosure, what are the next steps?
Once we reviewed the disclosure and addressed any gaps, we usually organize a Crown pretrial. This is a meeting with the Crown to discuss the case, potential resolutions, and any remaining issues. It's a crucial step in moving the case forward.
Well, Richard, this has been so insightful. Do you have any final advice for someone who is currently going through the disclosure process?
Yes, stay patient and trust your legal team. Disclosure is a complex but essential part of the process. The more thorough we are at reviewing it, the better prepared we'll be to build a strong defense.
Thank you so much, Richard. And thank you to everyone else watching Legally Speaking. Don't forget to like, comment, and subscribe for more legal insights.
Thanks, Melanie. See you next time.
Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.